Beacon Press Audio presents After Dobbs, How the Supreme Court Ended Roe But Not Abortion, by David S. Cohen and Carole Joffe. This audiobook is narrated by Carole and Jania, published by Beacon Press Audio 2025. To those fighting for reproductive freedom. Introduction. Ohio. Sometime in May 2022, a 10-year-old girl was raped in Ohio, and then, sometime after that, the girl found out she was pregnant. Given her age, the circumstances, and her wishes, she and her family decided she would have an abortion. Had they made the decision just days earlier, they would have encountered hurdles for getting an abortion in Ohio, but they could have been overcome. For instance, Ohio had required minors to obtain the written consent of a parent before getting an abortion. But this requirement wouldn't have posed a problem for the minor. Her parent supported her care. So she would have been able to obtain the consent and then care at one of the clinics or hospitals in Ohio that performed abortions. She would have done so, presumably, without the rest of the world finding out about her story. However, because she sought her abortion on June 29, 2022, rather than a week earlier, events took an entirely different turn. Instead, this girl's story became one of the first known tragedies of the Supreme Court's decision to overrule Roe v. Wade. On June 24th, just days before the 10-year-old sought an abortion, the court decided Dobbs v. Jackson Women's Health Organization, and that changed everything. On that Friday morning, the court announced its decision the same way it had been announcing all of its decisions in the COVID era, by releasing them not in person, but rather on the court website. With several opinions still left to be released for the term, and the blockbuster Second Amendment case New York State Rifle and Pistol Association v. Bruin having been released the day before, there were many people, including both of us, who thought the Supreme Court was going to wait to release Dobbs until the next week, possibly even the last day of its term. Issuing too many ground-shifting decisions that tracked the conservative agenda in rapid succession might not be the look the court wanted. We were all wrong. After issuing a decision at 10:01 a.m. Eastern Time about Medicare reimbursement that featured two of the court's conservatives joining the court's three liberals, as had become its custom, the court let 10 minutes pass before posting its next decision on its website. At 10:11 a.m., Dobbs appeared on the court's list of decided cases, and the moment anti-abortion activists had been waiting nearly half a century for had arrived. Clicking on the link revealed what we had all suspected. The court, voting on ideological lines, had overturned Roe v. Wade. For the 10-year-old girl's purposes, this decision on Friday morning could not have come at a worse time, and she could not have lived in a worse state. Whereas many other states took days or even weeks to sort out the consequences of the decision, Ohio took less than an hour. Just 45 minutes after the Supreme Court released its opinion, Ohio Attorney General Dave Yost filed a motion in Ohio federal court asking it to allow Ohio to enforce its ban on abortions after 6 weeks of pregnancy. That ban, passed in 2019, had been put on hold by an Ohio federal judge because it violated the right to abortion from Roe and its follow-up case, Planned Parenthood of Southeastern Pennsylvania v. Casey. In his motion filed that morning, Yost asked the court to immediately overturn its previous decision that had put the 2019 ban on hold. The ruling in Dobbs, Yost wrote, represents a substantial change in the law. Later that day, the court agreed with Yost. Ruling just after 6 p.m. that evening, the federal judge lifted the injunction that had stopped the 2019 law from taking effect. Reflecting the gravity of the moment, the judge wrote that the Supreme Court's overruling of Roe meant the judge needed to take immediate action. As a result of this decision, by Friday evening, barely 8 hours after Dobbs was released, Ohio became the first state in the country to have an abortion ban restored. 5 days later, several Ohio abortion clinics asked the state Supreme Court to stop the ban, but the court did not act on that request. This legal wrangling taking place in Ohio's state and federal courts probably went unnoticed by the 10-year-old and her family. However, these decisions had an almost immediate impact on their lives. The abortion ban now in place had no exception for rape and prohibited abortions after the detection of what the law called a fetal heartbeat, even though there is nothing medical professionals would ordinarily call a heartbeat early in pregnancy. It explained further that an abortion provider must determine if there is cardiac activity, which occurs at around 6 weeks of pregnancy. But 6 weeks of pregnancy is not what most people typically think it is. Pregnancy is dated from the start of the last menstrual period, so a pregnancy that is 6 weeks along is often, if the person has a regular menstrual cycle, only 4 weeks after conception and 2 weeks after missing a period. In other words, with the Ohio law now in place, people in the state had a very short time to navigate the obstacle course of finding out they were pregnant, making a decision to get an abortion, finding a clinic, getting an appointment, complying with all of the state requirements for an abortion, and then having the abortion. For this 10-year-old girl, it was now too late. She went to see a doctor in Ohio on the Monday following the Supreme Court decision. But because Dobbs had been decided 3 days prior to that visit, rather than, say, 3 days after it, the doctor couldn't help her get an abortion in her home state. According to media reports, she was just a few days past her state's now in effect 6-week limit. So the 10-year-old, with parental help, did what many people had to do after Dobbs. She traveled to another state where abortion remained legal. For this girl, that meant going to Indiana. There, she had her abortion and was able to move on to dealing with the trauma of being raped, but without also dealing with being pregnant and eventually giving birth at such a young age. Ordinarily, that would have been the end of the story about her abortion, and nothing about it would have been publicly known. However, on July 1st, 1 week after Dobbs was decided, the Indianapolis Star published an article about abortion patients traveling to Indiana for abortion care, now that states near Indiana, like Ohio, had criminalized abortion. The article started with a brief anecdote told by Dr. Caitlin Bernard, an obstetrician-gynecologist who practices in Indianapolis. Dr. Bernard relayed the story of taking the call from the 10-year-old's Ohio doctor and then the girl coming to Indianapolis, where Dr. Bernard performed her abortion. There were no other details. Nonetheless, the story went viral. Scores of news outlets around the United States and the world ran with it. No doubt partly because it is a tragically sad story, but also because it drove home the harm of Dobbs with about as sympathetic a victim as possible. President Joe Biden even weighed in while talking about the Supreme Court and the future of abortion. He said, with increasing emphasis and passion as he spoke, "Just last week it was reported that a 10-year-old girl was a rape victim in Ohio. 10 years old, and she was forced to travel out of the state to Indiana to seek to terminate the pregnancy and maybe save her life. That last part is my judgment. 10 years old. 10 years old. Raped, 6 weeks pregnant, already traumatized, was forced to travel to another state. Imagine being that little girl. I'm serious, just imagine being that little girl, 10 years old." Because of this story's power, it immediately drew backlash. Anti-abortion politicians and news outlets asked whether the story was true or merely made up out of whole cloth by someone they accused of being merely an abortion rights activist. They insisted that if these events had actually taken place, certainly a parent or a doctor would have reported the horrific crime, and there would be a record of an arrest or an investigation.
Sample complete. Ready to continue?